Honourable members, we've taken decision on clause 4. So can we move to clause 5? Yes.
Speaker, we had moved clause 5. Sorry. Okay, sorry.
Yes, Honourable.
Speaker, respectfully, there was a situation before you called for suspension.
Very well.
And I thought you were going to proceed with that situation for us to have it resolved before you proceed.
Very well. The floor is open for the submission. Because I have not seen Habib. But if you have the authority, you may please raise the issue.
Yes, Speaker, Habib requested that we look at 151, order 151 then. And I thought that we were going to proceed on that tangent.
Read order 151 and raise the issue.
Mr. Speaker,
yes.
We need to know whether he is raising an issue or Habib is raising an issue. Because Habib can choose to be in the chamber. If he has decided not to be in the chamber, whatever issue he was raising, which is a personal matter, is deemed abandoned. Is deemed abandoned. So if he wants to raise the issue, he should man up and raise the issue. And don't bring Habib into the equation. So be bold. Raise the issue. Raise the issue. But don't say Habib, no. If you want us to wait, we can wait. We can give you time for Habib to come. We can give Habib time to come. I said we can give Habib time to come. You know, he's supposed to be here. So unless you want to raise it, if you want to raise it, I don't have a problem.
Mr. Speaker, I was in this chamber when my colleague raised the issue. That was the matter for which this House was suspended. At the time the issue was raised in reference to 151, Speaker, that was when. Speaker, unless Hansard has not captured it, when that was raised, they were 23. If they have come and we are insisting that whatever Habib said is what we are proceeding with.
Honorable Deputy Minority Whip. Honorable Deputy Minority Whip. Habib was about raising the issue, but I did not give him the floor to do so. Because Majority Leader raised the issue of suspension. That is why he is saying that Habib having not raised the issue, if you are mindful, you can raise the same issue and we'll give it consideration. If not, we make progress.
Speaker, respectfully, I come under order 151. 1513 in particular, and with your permission, I read. Speaker, 1513. A member may challenge the decision of the Speaker on the voice vote, and the Speaker shall determine whether to call for head count or electronic vote. Speaker, the basis of our call on you, respectfully, is to say that we would need a head count on this matter. We will need, Speaker, we will need a head count of each and every member to determine the true reflection of the votes. Speaker, I so pray.
Honourable members, by the rules, if Order 1513 is invoked, challenging the decision of the voice votes. The procedure is spelled out in Order 152. And 1521 says that the Speaker shall take the vote of the House in the case of a head count by calling upon members who support or oppose the question to rise in their place successively. On that note, I will call on the minority who supports the motion to stand up to be counted. Yes.
Speaker, with respect, before we take the head count, I want to bring to your attention a preliminary observation. Speaker, with respect, when the application was made and the majority leader requested for suspension, they had only 37. Mr. Speaker, the people in this room who are now going to be part of the appeal process were not here. They were not here. How can they? They were not part of the earlier voting. The majority leader used this strategy to bring them in. If you are not part of the original vote, how can you be part of an appeal process? Mr. Speaker,
so
I just want to bring to your attention.
Are
they
you,
were not here.
by your suggestion, saying I should not proceed with the process?
I haven't said so. I'm saying I am bringing to your attention a preliminary objection matter. The preliminary observation is that when we voted earlier, the subject matter of the recount, the head count, the subject matter of this appeal, the majority leader, I told you that he had a strategy to request for suspension, so that he uses the suspension, which has taken 5 hours of suspension, to populate this chamber. How can they participate in the voting? All these people who have suddenly entered the room, all these people, 5 hours, all of a sudden, and you said they should participate in the process.
Honourable Minority Leader,
Mr. Speaker, let me finish my
with
observation.
all due respect, I have never ordered any counting. Honourable members, let's listen. I have never ordered any counting. For that matter, I wouldn't be able to determine the numbers. Now, Jerry has buttressed the points, and I'm following the procedure in Order 152 and calling for head count. That is why I'm calling on the minority to stand up to be counted. So,
Mr. Speaker,
table.
Mr. Speaker, respectfully, Mr. Speaker, without prejudice to the processes you have initiated, I am saying that there is a preliminary observation I have made, and I want your determination on the preliminary observation. Mr. Speaker, the preliminary observation I have made is that, Mr. Speaker, at the time of the first voting, Mr. Speaker, there were only 35. The majority leader has used 5 hours to marshal his members, so that, yes, Mr. Speaker, he can tilt the head count.
So are you calling on me to rule?
Mr. Speaker, yes, I would want to. So let me finish the application.
Very well.
Let him oppose it and rule. So let me finish. Mr. Speaker, it is our case as minority that those who participated in the no vote, Mr. Speaker, the no's were just 35. We counted. As we speak, Mr. Speaker, the foreign minister was not here. The respected finance minister was not here. Mr. Speaker, the lands and natural resources minister was not here. Mr. Speaker, all those backbenchers, they populated this room. They were not here. They were not here. Now, Mr. Speaker, they have brought them to participate in a vote they were not part of originally. How can you do this? Mr. Speaker, how is this possible?
Honorable Majority Leader, just resume your seat. Honorable Majority Leader, Majority Leader, just take it easy, resume your seat. Please, conclude.
Mr. Speaker, those who participated in the no vote, the application was to the effect that we should delete clause 4 of the bill. And you put the question, the no's, we counted. And it is true you didn't order any counting. But, Mr. Speaker, at that material time, Mr. Speaker, you may protect me. Mr. Speaker may protect me. The shouting. Mr. Speaker, you may have to protect me. The shouting. The shouting.
Please. Honorable members, with all due respect, let's listen to each other.
The minority leader must be heard.
Let's listen to each other.
Mr. Speaker, you call the vote, and when you call the vote, the ayes voted. I was the applicant, and my prayer was to the effect that clause 4, entire clause 4, be deleted. And Mr. Speaker, after listening to all the argument, you put the question. The ayes voted, and the no's were just 35. Mr. Speaker,
well,
then we
Honorable
rose.
Minority Leader, with the issue that you have raised, I got the issue that you have raised. But let me advent your mind to Standing Order 152.2. It reads, a member may vote on any question put, even if the member did not participate in the deliberation on the matter.
Mr. Speaker,
This is Standing Order 152.2
Mr. Speaker,
of the rules book.
Mr. Speaker,
So what issue are you raising?
Mr. Speaker, respectfully, 1522 talks about deliberation. And that's not the issue I'm raising. Mr. Speaker, that is different from the issue I'm raising. The issue I'm raising is to the effect that, Mr. Speaker, the majority leader used a means of mischief, bad faith, Mr. Speaker, to create this scenario. Mr. Speaker, he suddenly rose on his feet when our application for the head count was about being moved. He now said that the house should be suspended. And Mr. Speaker, you obliged him by saying that he's an important person. Mr. Speaker, can you, Mr. Speaker, I respect Honorable Adongo. I know he's a member of the Bank of Ghana board. Mr. Speaker, see where he's seated. They strategically brought him here to come and heckle the minority leader. Mr. Speaker, see where he's seated. A member of the Central Bank board. A happy member, Mr. Speaker.
Honorable Minority Leader,
Yes.
you raised an issue calling on me to provide a ruling.
Yes. They should
And
allow
I'm
me to
drawing
make
your
my application.
attention to a particular order.
Mr. Speaker, they should make me.
Will you
Mr. Speaker,
allow
I'm
me
making my point, but they
to
are
deliver a
Mr.
full
Speaker,
ruling?
The house, there's too much noise in the house. It's creating problems. Mr. Speaker, bring them to order. I need to make my application. Mr. Speaker, my argument is that Order 1522 in its form and shape is talking about deliberation, meaning that when a member is not even in the chamber, he can come and vote. I agree. That is not what I'm saying. What I am saying, and the invitation to you as a presiding officer, is to the fact that where members are not part of a voting system, they did not vote, they were not here to vote, but a majority leader, knowing that he is losing a case, decides to apply for suspension. Then after 5 hours decides to populate. Why are you turning your face this way? Decides to populate the chamber with, Mr. Speaker, backbenchers who were not in the chamber, cabinet ministers who were not in the chamber. Mr. Speaker, the argument is whether or not those who did not participate in the voting can now come and use their presence to tilt the voting in a certain direction. Mr. Speaker, that is a call on you. Mr. Speaker, I submit that they not being in the chamber, they are stopped.
Honorable
Let's
Minority
deal with the
Leader,
35.
if you call on the Speaker,
Yes.
then you resume your seat and also listen
Mr.
to the Speaker
they are
as
making
well.
noise. I can't hear you. They are making noise.
Saying
I
that,
can't hear you.
I'm saying that once you call on the Speaker, then you resume your seat and then listen to the Speaker. Or if there is any response from the majority side, we take the response and then you listen to the Speaker and we conclude the issue. So, Majority Leader.
Mr. Speaker, the matters are very simple. He wants a head count. As for where I get the MPs from, that is not his business. Where I get the MPs from is not your business. I have always said that the practice of this House has been that you don't need everybody in the chamber to carry out business. But when a vote is about to take place, we will find the numbers when we need them. Mr. Speaker, it should be known that this is a side that is in government. If you look at the cabinet and the ministers, a majority of the ministers are members of parliament. About 90% of the ministers are members of parliament. And many other members of parliament are serving on boards. Many others are chairing committees with international responsibilities. So it is not at all times that on every vote I will have everybody sitting in this chamber. But when reasonable time is given, we will make sure everybody is in this chamber. So, as for your arguments, I don't see the basis of the arguments. The Speaker has drawn your attention to the standing orders. The standing orders say that the fact that a member did not participate in the prior deliberations. Deliberations in this House includes voting. It includes the debate and the voting. That is the deliberation in this House. So the fact that members were not in during the first vote doesn't mean that when they arrive and then you are going to do head count, they cannot be counted. Because what happened earlier was deliberation of the House, including the vote that took place. What you are saying, that there were 36 people here, is clearly untrue. Totally untrue. The only person who can certify the number of people in the chamber is the speaker. And the speaker did not count. The speaker took a voice vote. You are demanding a head count. So it is now that the speaker is going to count. And the numbers that the speaker gets now is a reflection of those who have voted for the matter. That's how this house is managed. So I plead with you, if you don't want more people to come in, let's take the head count now. Because the more you delay us, the more people come in. As you can see, the foreign affairs minister was in the Volta region with the president. And I called him and he came back. There are people who came all the way from Northern region. There are some of our colleagues here who were in Yendi to attend the 3 days, Adua of our late King Diana. Because of you, I have brought all of them back. So I don't know what the basis of your objection is. So you have called for head count. Let's do the head count and move on, Mr. Speaker.
Honorable members, I think I've listened to the minority leader as well as the majority leader. This is what the chair has to say. Honorable members, by no parliamentary procedure can a speaker be called upon to rule on observation. The fact that the majority leader managed to bring the number or so and so, I have not ordered any counting. So that clearly is an observation by the minority leader. In no democratic parliament would a person presiding be called upon to rule on observation. That is unknown to our rules and the practice of this house. Secondly, the procedure is clear that when Order 1513 is invoked, the person presiding must apply the procedure set out for it in Standing Order 152. In dealing with Standing Order 152, Standing Order 152-2 states clearly and unambiguously that a member may vote any question put even if the member did not participate in the deliberation of the matter. I therefore find the issue raised by the minority leader unmeritorious, frivolous, vexatious, and baseless in terms of our procedure. It is therefore dismissed. Honourable members, I will call on the minority who voted aye to stand up to be counted. Honourable members, the call is for the minority to stand up to be counted.
Speaker,
Clerk at table.
Speaker,
on this note,
Speaker,
you may do the counting.
I am on my feet with an application. Mr. Speaker, before you proceed to do the head count, the Constitution provides under Article 104(1) except as otherwise provided in this constitution. Matters in Parliament shall be determined by the majority of members present and voting, with at least half of all members of Parliament present. So, Mr. Speaker, since we are going to take a decision, I hold a view that to ensure fidelity to the Constitution, let us first establish that Parliament as constituted now, we have a decision-making quorum. And Mr. Speaker, I am moving that currently this House is not properly constituted for the purpose of decision-making. We are not properly constituted, so we need to cross the first leg before we get to the second leg of the head count. This is a constitutional bona fide. 104 requires that there must be at least 138. So, Mr. Speaker, let us establish that. That is fundamental. Since the majority leader says that he has more numbers, it's fine. Let's establish that. And you must certify that first. You must certify that first, that we have a decision-making quorum. Then we can move to the next step to do the head count.
Honorable members, with all due respect, there is an application on the floor. And when the application is on the floor, you deal with that application. You don't abandon that application to take another application.
You can't.
This is not how things are done. There is application by the minority, deputy minority chief whip, which application we have to deal with.
Mr. Speaker, you have every right to intervene, but sometimes I am tempted to believe that you don't pay attention to all my submissions. Mr. Speaker, preliminary, please. When the majority leader was on his feet, everybody here was quiet. Stop this. And the speaker will not reprimand you. When it is us, he will reprimand. When it is you, he doesn't reprimand. The speaker is one-sided. Mr. Speaker, I call for immediate suspension. Mr. Speaker, I hereby apply for suspension of the House. When the majority leader applied for suspension, you granted it. Mr. Speaker, I call for suspension. Mr. Speaker, when the majority leader called for suspension, you granted this application. I hereby call for suspension of the House for some 5 minutes.
Majority leader.
Yeah, Mr. Speaker, you see, on several occasions, I rose up. You were also standing there. I waited to catch the eye of the speaker before I will utter a word. This last instance, I actually stood up first to try to catch the eye of the speaker. You stood up. You did not wait to catch the eye of the speaker. You just put the mic on and you started talking. He didn't call you. You see, so when you say that, when you do that, then you turn and accuse the speaker that he's being unfair, he's being one-sided, and etc. It's not fair. I will never open my mouth until I have clear instruction from the speaker that I never do that. You watch. You watch me carefully. I never speak until I have caught the eye of the speaker. He has given me indication that go ahead and speak. So when people react from this side, it is because, truth be told, you're not going according to the rules. You are not going according to the rules. When we came, you were not even in the chamber. Speaker asked him whether or not the issue of head count was still pending. Then he got up and said it was Habib And we said, no, wait. If you want to raise the question of numbers, go ahead and do it. Don't mention Habib. So we proceeded to give him the opportunity to raise an issue under Order 151. And so what we have to do is to count the heads. Let me assure you, let me assure you that we respect. If we didn't respect you, we would not suspend and get everybody in the chamber. It's a sign of respect. It's a sign of respect. So also respect us by allowing us to do the head count so that we can continue. I can assure you that even if we will sit here till tomorrow morning, this bill will pass it today. We will pass it today. You can filibuster, you can do all the things that you want to do. I have your time. I have your time. We will pass this bill today. So you can go on. You can go on. Those of us who have done student politics, this is common. We go for a Nooks meeting and we filibuster until 4 a.m. when everybody is sleepy. Then that's when we take the vote. So if you want that, we can do Nooks politics here. After this bill, we will pass it today.
Yes, Minority Leader. Yes, Minority Leader.
Mr. Speaker, Mr. Speaker, a day or so ago, you sat there was communication here, and you said you heard. The Minister for Lands and Natural Resources is being abusive. He is abusing me. Mr. Speaker, he is abusing me. And Mr. Speaker, when we talk, it's as if we are complaining, but that is the truth. We are being treated as if we are orphans in this chamber. Mr. Speaker, you will always reprimand our side. When it gets to the minority leader, questions upon questions. But when it is your side, no question. You gave me the opportunity to speak. Minister for Natural Resources was shouting, abusing me. No bread from the presiding officer.
Honorable Minority
Mr.
Leader,
Speaker, it is,
with all due respect,
Mr. Speaker, with all due respect to
I
me
will
too.
not take it anymore from you to accuse me of unfairness. It's enough. I cannot take it anymore. I can't take it anymore. Every day, you accuse me of being unfair. This is not how I expect leaders to treat me.
Mr. Speaker, I am expressing a feeling. Mr. Speaker, I'm expressing a feeling and how they are reacting to me. Mr. Speaker, we are only 87. If the presiding officer doesn't protect us, who else will protect us? Who else will protect us? We are just 87 in this chamber. They come to intimidate. Even if you want to speak, they don't want you to speak. Who else will protect if you don't protect us? I am protesting and it's my right. It's not against your person. Protect me and protect the minority. The minority must be protected. Our voice must be heard. That is the law. It It is in our standing orders. Mr. Speaker, it is our case that since we have a preliminary objection issue regarding decision-making quorum, if you make a determination that you can only we can only raise it after the head count, I will resume my seat. But our case, we want Hansa to have it, that once a constitutional issue has been raised, all other matters must stay until that matter is determined. This is our case. This is our case. So if you make a determination, we'll be obliged.
Very well, I'll make it. I'll make the
decision.
Determination. Honorable members, a decision-making quorum is supposed to be raised at the point of making the decision. Now, Order 151 is invoked to challenge a decision that has already been made. So, if Order 151 is invoked to challenge a decision that has been made, the procedure available for us is Standing Order 152. You do not go to raise another quorum when a motion has been moved to challenge a decision that has already been taken. So by our rules, once a motion is moved to challenge a decision of the Speaker, the procedure available is Standing Order 152. That is what we are adopting. Honourable members, when the procedure is set down for a right to be exercised, it is only that procedure that will have to be followed in exercising the right. Therefore, let's follow the procedure. Those who voted in support, stand up to be counted. Clerk at table, you may do the counting. So, according to the clerks at table, they have finished, so you may kindly resume your seat. They have finished, so you may resume your seat. Those who voted no, stand up to be counted. Honourable members, you can now resume your seats. Honourable members, declaration of the results. The total votes, or let's say those who voted aye, after counting, they numbered 16. Those who voted aye, who were up to be counted, is 134. Honourable members, by the Supreme Court decision in the case of Justice Abdullahi versus Attorney General, when the person presiding is a deputy speaker, he is entitled to vote. Accordingly, I am also voting aye. So the votes, I'm also voting no. I am voting no. So the votes, the total vote for the no is 135. The speaker is added. Now, the total vote cast. Honourable members, the total vote cast is 151. And total vote of 151 satisfy the constitutional requirement in Article 104. Therefore, Clause 4 is ordered to stand part of the bill. Yes, Minority Leader.
Mr. Speaker, we have done our own counting of the majority members. Mr. Speaker, they are 113. But, Mr. Speaker, in the interest of democracy, we haven't registered our protest. Okay. Mr. Speaker, since the majority leader has indicated that they will not listen to the views expressed, including that of organized labor, Mr. Speaker, we are leaving them. Debbie. I take responsibility. Let's go. There's no point. Mr. Speaker, the majority leader has let the cat out of the bag. He says that the door is shut. It is not only the minority that is raising issues against this bill, but organized labor has also done so. If he says they want to go ahead, Mr. Speaker, if he says they want to go ahead, and Mr. Speaker, when the majority leader speaks with all his authority, say today, he says he will pass. Mr. Speaker, the Constitutional Review Committee has spoken against this bill. They said they will do what they want to do. Mr. Speaker, we are Democrats. We are not going to be part of this Rambo style of, Mr. Speaker, destroying the judiciary. They started by sacking the Chief Justice. After sacking the Chief Justice, they also allowed contingency fund account to be garnished. Now they want tribunal to be made up of non-lawyers, non-judges, to prosecute people. Mr. Speaker, they should do what they want to do.
On point of relevance, you are being out of order. Yes, Majority Leader.
Yeah, Mr. Speaker.
Majority Leader.
Mr. Speaker.
Honorable members. Honorable members, order. Honorable members, order. Honorable members.
Mr. Speaker.
For the purposes of clarity,
Yeah.
let me repeat the results. The minority who voted aye were counted 16. The majority who voted no were 134. And the decision of the court in Justice Abdullahi versus Attorney General is that when the person presiding is a deputy speaker, he represents a constituency. Therefore, his vote cannot be taken away from him. I'm therefore exercising my vote to support the no, making the no 135. The total number of votes cast is 151. Honorable members, the Supreme Court's decision in the case of Justice Abdullahi versus Attorney General is now part of our Standing Order 1525. And I read, where a deputy speaker or a member is presiding, the deputy speaker or a member shall communicate his personal votes to the clerk at the table to be added to the collated results before the results of the vote are declared. So the decision of the court is captured by our own standing order. So the total vote for today is 151. Honourable members, can we make progress? Clause 5. Chairman of the committee.
Mr. Speaker, we had already taken clause 5, but let me just go over it. Amendment proposed, head note, delete tribunals and insert.
We have taken a vote on the 5 before he brought us back to 4. So we now move to clause 6.
6, yes. Mr. Speaker, rightly so.
So you may move clause 6.
Relationship between tribunals and the judicial system.
Mr. Speaker, clause 6, amendment proposed, delete tribunals and insert tribunal. I so move, Mr. Speaker.
Honourable members, the proposed amendment by the chairman of the committee is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Aye. Those against say no. Honourable members, the proposed amendment is ordered to stand part of the bill. I will then put a question on entire clause 6 in the absence of any further. Yes, chairman of the committee.
Mr. Speaker, there's a further amendment to clause 6(4). The proposed amendment is to add regional tribunals as A. So a district tribunal is bound by a decision of A, regional tribunal, the regional tribunal, the High Court, the Court of Appeal, and
I'll put a question. Those in favor say aye. Aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and I will direct the drafters to renumber clause 5(4). I will then put the question on the entire clause 6.4. I will then put the question on the entire clause 6. As many as are in favor say aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part of the bill. Clause 7.
Composition of Regional Tribunal.
Speaker, amendment proposed, subclause 1, paragraph B, delete 1 and insert A. I so move, Mr. Speaker.
Yes. Honorable Chairman of the committee, have you advented your mind to Article 142B? Why are you trying to change the constitutional language? The constitutional language is as captured here. So why are you changing it? Have you seen it?
Mr. Speaker, I'm minded to avert my mind to the constitutional provision.
You are minded to...
Yeah, so I will abandon the...
Very well. The proposed amendment abandoned. Honourable members, I will then put a question on clause 7. As many as are in favor of clause 7 standing part of the bill say aye. Those against say no. The ayes have it. Clause 7 is ordered to stand part of the bill. Clause 8.
Qualification of members of a regional tribunal.
Chairman of the committee.
Mr. Speaker, amendment proposed, subclause 1, line 1, after with, delete clause 1 off. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, VI.
VI, amendment proposed, Mr. Speaker, subclause 1, paragraph B, delete and insert the following. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. I will then put a question on the entire clause 8 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 8 is ordered to stand part of the bill. Clause 9.
Composition of District Tribunal.
Chairman of the committee.
Mr. Speaker, I want to abandon clause 9. It will run the same way as clause 7. I so abandon, Mr. Speaker.
Very well. I will then put a question on entire on clause 9. Those in favor say aye. Those against say no. The ayes have it. Clause 9 is ordered to stand part of the bill. Clause 10.
Qualification of members of a district tribunal.
Chairman of the committee.
Mr. Speaker, no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, honourable members, I'll put a question. Those in favor of clause 10, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 10 is ordered to stand part of the bill. Clause 11.
Appointment of chairman of tribunal and panel members.
Chairman of the committee, you may move amendment VIII.
VIII, Mr. Speaker, amendment proposed, subclause 1, delete and insert the following as advertised on page 16. I so move, Mr. Speaker.
All members, the proposed amendment by the chairman of the committee is for the consideration of the House. In the absence of any further proposal, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question to entire clause 11 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 11 is ordered to stand part of the bill. Chairman of the committee, you may move the new clause after clause 11.
Mr. Speaker, with your permission, may I move that after clause 11, insert the following new clause as captured on page 16. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question on the new clause. Those in favor say aye. Those against say no. The ayes have it. The new clause is ordered to stand part of the bill. Clause 12.
Retirement and resignation of Chairman of Regional and District Tribunals.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 12 is ordered to stand part of the bill. Clause 13.
Removal of Chairman of Tribunals and panel members.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, do you have any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 13. Those in favor say aye. Those against say no. The ayes have it. Clause 13 is ordered to stand part of the bill. Clause 14.
Code of Conduct and Disciplinary Rules.
Chairman of the committee.
No advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 14 is ordered to stand part of the bill. Clause 15.
General Jurisdiction of Tribunals.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 15? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 15 is ordered to stand part of the bill. Clause 16.
Jurisdiction of Regional Tribunal.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. Those in favor of clause 16 standing part of the bill say aye. Those against say no. The ayes have it. Clause 16 is ordered to stand part of the bill. Clause 17.
Powers of Regional Tribunal.
Speaker,
Chairman of the committee.
Clause 17, amendment proposed, paragraph B, line 2, delete may and insert has power to. I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, any further amendment? I'll put a question on the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 17 is ordered to stand part of the bill. Now I'll put a question on the entire clause 17. As many as are in favor say aye. Those against say no. The ayes have it. Clause 17 as amended is ordered to stand part of the bill. Clause 18.
Decisions of Regional Tribunal.
Chairman of the committee.
Mr. Speaker, clause 18, amendment proposed, after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 18 is ordered to stand part of the bill. Now I'll put a question on the entire clause 18. Those in favor say aye. Those against say no. The ayes have it. Clause 18 is ordered to stand part of the bill. Clause 19.
Jurisdiction of District Tribunal.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 19. Those in favor say aye. Those against say no. The ayes have it. Clause 19 is ordered to stand part of the bill. Clause 20.
Powers of District Tribunal.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any amendments? Those in favor of clause 20 standing part of the bill say aye. Those against say no. The ayes have it. Clause 20 is ordered to stand part of the bill. Clause 21.
Decisions of District Tribunal.
Chairman of the committee.
Speaker, clause 21, amendment proposed, after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment standing part of the bill say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now the question is on clause 21 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 21 is ordered to stand part of the bill. Clause 22.
Concurrent jurisdiction with other courts and limitations.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any amendment to clause 22? In the absence of any amendment, I'll put a question to clause 22. Those in favor say aye. Those against say no. The ayes have it. Clause 22 is ordered to stand part of the bill. Clause 23.
Matters excluded from the jurisdiction of a tribunal.
Chairman of the committee.
Mr. Speaker, clause 23, amendment proposed after paragraph B, insert the following new paragraph. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question onto the proposed amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on entire clause 23 as amended. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 23 is ordered to stand part of the bill. Clause 24.
Reference to the Supreme Court.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 24 is ordered to stand part of the bill. Clause 25.
Rules of procedure before a tribunal.
Chairman of the committee.
Mr. Speaker, clause 25, amendment proposed after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? I'll put a question onto the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 25 is ordered to stand part of the bill. I'll put a question on the entire clause 25 in the absence of any further amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 25 as amended is ordered to stand part of the bill. Clause 26.
Mode of trial.
Mr. Speaker,
Chairman of the committee.
no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 26? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 26 is ordered to stand part of the bill. Clause 27.
Right to legal representation.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 27 is ordered to stand part of the bill. Clause 28.
Application of Evidence Act 1975, NRCD 323.
Chairman of the committee.
Mr. Speaker, amendment proposed under 28 is to delete the entire clause. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 28 is ordered to be deleted from the bill. Clause 29.
Proceedings to be open to public.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 29 is ordered to stand part of the bill. Clause 30.
Live broadcast of public interest cases before regional tribunal.
Chairman of the case, Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 30? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 30 is ordered to stand part of the bill. Clause 31.
Restrictions on media coverage of proceedings of district tribunal.
Chairman of the committee,
Mr. Speaker, no advertised amendments.
it is for the consideration of the House. Honourable members, any proposed amendment to clause 31? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered to stand part of the bill. Clause 32.
Compliance with procedural safeguards.
Chairman of the committee.
Mr. Speaker, clause 32, amendment proposed is to delete the entire clause. I shall move, Mr. Speaker.
Now, members, the proposed amendment is for the consideration of the House. Any further amendment? Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered not to stand part of the bill. Should be deleted. Now, clause 32 is ordered not to be part of the bill. Is deleted. And I direct the drafters in view of the deletion in 28 on 31 to check the renumbering. Clause 33.
Application of sections 34 to 42.
Chairman of the committee.
Mr. Speaker, there's no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 33? Honourable members, in the absence of any proposed amendment, I'll put a question. Those in favor of clause 33 standing part of the bill say aye. Those against say no. The ayes have it. Clause 33 is ordered to stand part of the bill. Clause 34.
Mode of instituting proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 34? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 34 is ordered to stand part of the bill. Clause 35.
Service.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 35? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 35 is ordered to stand part of the bill. Clause 36. Clause 36. Clause 36.
Defense of accused person and preliminary objection.
Chairman of the committee.
Mr. Speaker, no advertised amendments for this.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor of clause 36 standing part of the bill say aye. Those against say no. Honourable members, the ayes have it. Clause 36 is ordered to stand part of the bill. Clause 37.
Electronic service.
Chairman of the committee.
Mr. Speaker, no advertised amendments.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 37? In the absence of any proposed amendment, the question is as many as are in favor of clause 37 standing part of the bill say aye. Those against say no. The ayes have it. Clause 37 is ordered to stand part of the bill. Clause 38.
Trial.
Chairman of the committee.
Mr. Speaker, clause 38, amendment proposed, subclause 4, delete and insert the following as advertised on page 18. I shall move, Mr. Speaker.
Honourable members, those in favor of the proposed amendment by the chairman of the committee say aye. Those against say no. The ayes have it. The proposed amendment by the chairman of the committee is ordered to stand part of the bill. Any further amendment to clause 38? In the absence of any further amendment, I'll put a question. Those in favor of clause 38 standing part of the bill say aye. Those against say no. The ayes have it. Clause 38 is ordered to stand part of the bill. Clause 39.
Interlocutory appeals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 39? In the absence of any proposed amendment to clause 39, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 39 is ordered to stand part of the bill. Clause 40.
Stay of proceedings.
Chairman of the committee,
The Speaker, no advertised amendment.
it is for the
Clause
consideration
40.
of the House. Honourable members, any proposed amendment to clause 40? In the absence of any proposed amendment, I'll put the question. As many as are in favor, say aye. Those against, say no. The ayes have it. Clause 40 is ordered to stand part of the bill. Clause 41.
Day-to-day trial of case.
Chairman of the committee may move amendment XVIII.
Mr. Speaker, amendment XVIII, clause 41, proposes sub-clause 1, line 2 and 3, delete a day-to-day and insert an expeditious. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question to the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XIX.
Mr. Speaker, XIX, subclause 2, line 1, delete a day-to-day and insert an expeditious. And in line 3, delete 14 and insert 7. I so move, Mr. Speaker.
So let's take this. I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XX.
Amendment proposed XX is to delete the entire clause. I so move, Mr. Speaker.
Honourable members, any further amendment to the amendment proposed by the chairman of the committee? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, yes. Honourable Majority Leader.
Yeah, Mr. Speaker, I know you've passed 41 already, but...
We are now on 41.
We're now on 41.
Yes.
Yeah, 41 line...
So let's finish putting the question on this. Before I put a question on entire clause 41, then you can raise your issue. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and consequently, sub-clause 3 is deleted. Yes? Majority Leader.
Yeah, Mr. Speaker, if we can go back to where we try to delete day-to-day and then insert an expeditious. If you say shall proceed on an expeditious basis, proceed on an expeditious basis, I doubt if that is a proper coherent rendition, because what it says is that delete day to day and then leave basis, and in place of day to day you say an expeditious basis. That's not
so
accurate.
The rendition will be a trial commenced under the Minerals and the Mining Act 2006, Act 703, shall proceed on an expeditious basis until the conclusion of the trial, except where an expeditious trial is impracticable.
So the proper rendition should be shall proceed expeditiously. Shall proceed expeditiously until the conclusion of the trial, except where an expeditious trial is impracticable. That would be a proper rendition.
Very well. Chairman of the committee.
Mr. Speaker, I'm minded to go with
Very well.
leader on
Then I'll then put a question on the amendment proposed by. Yes, leader. According to the drafters, that it will be problematic. So we should leave it the way it is. Yes, Majority Leader.
Yeah, Mr. Speaker, the thinking is that the court should sit daily, because one of the issues that the whole architecture of the tribunal system is meant to deal with is adjournments. The public outcry regarding, adjournments and how that frustrates the administration of justice. So the idea is to put pressure on a panel of the tribunal to sit every single day until they dispose of the matter, except where it is impracticable for them to sit every single day until the matter is disposed of.
So if you put it that way, what happens if the court did not sit on daily basis?
Well, the idea is that the court must sit on a day-to-day basis. That's the idea informing the reform, unless it is impracticable for them to sit, assuming that it rains and the whole area is flooded and their lives are at risk if they try to get to the tribunal, building, or some other circumstance that makes it impracticable, assuming that a member of the panel suddenly falls ill and therefore they cannot, constitute a panel to try the matter. But the principle is to deal with the adjournments that have tended to frustrate the administration of justice by demanding that they sit on a day-to-day basis to hear the matter and dispose of it expeditiously, unless that is not practicable. That's the principle.
Attorney General, what do you say to this?
Right Honorable Speaker, I support the initial rendition because, as the leader has pointed out, the idea is to ensure that the long adjournments are a thing of the past when it comes to the tribunals. And I think that day-to-day or daily is a more precise concept than expeditious. So I support the initial rendition that are brought in the bill.
Chairman of the committee, what do you say?
Mr. Speaker, this we debated for some time.
That's why I was deferring to my committee.
And so on the basis of that, I am now just seeing the deletion of 3 to tie in with getting back to the old rendition or the original rendition. Where
I'll prevail on you to abandon your amendment and let's allow what is in the bill to pertain.
Mr. Speaker, except to say that XX, I now want to see the same 41.
Because your amendment will also have impact on the head note.
On which one?
On the head note.
Because the head note says day-to-day trial of cases.
Yeah. So, Mr. Speaker, I will abandon clause 41. I will abandon XVIII and XIX. We will have to debate XX then.
Very well.
After the abandonment of
Very well.
2.
Very well. So, our members, Chairman has abandoned the proposed amendment that we put a question on. But in order not to have a problem, I'll put the question on the entire clause 41. Chairman having abandoned the proposed amendment in XVIII and XIV. Those in favor of clause 41, as amended standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 41, as amended in XX, to delete subclause 3, is ordered to stand part of the bill. Clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, may I get you right on X?
So the only amendment carried here
It's XX.
is XX.
Brilliant. That's fine.
That's what I'm saying. Clause 41, you have abandoned XVII,
Yes.
XIX. So the only amendment carried is in XX.
Very well.
That's why I use the word as amended in SX to delete subclause 3.
Noted, Mr. Speaker.
Very well. So we proceed to clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 42? I'll put a question. Those in favor of clause 42 standing part of the bill, say aye. Those against, say no. Honourable members, the ayes have it. Clause 42 is ordered to stand part of the bill. Clause 43.
Establishment of Tribunal Oversight Committee.
Chairman of the committee.
Mr. Speaker, clause 43, amendment proposed, delete and insert the following as advertised on page 18. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is as many as are in favor of the proposed amendment by the chairman of the committee, say aye. Those against, say no. The ayes have it. The proposed amendment to clause 43 is ordered to stand part of the bill. Now I put a question on clause 43 as amended. Those in favor say aye. Those against say no. Clause 43 as amended is ordered to stand part of the bill. Clause 44.
Membership of committee.
Chairman of the committee.
Speaker, XXII, clause 44, amendment proposed, subclause 1, paragraph A, delete and insert the following. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Clause 44.
XXII, Mr. Speaker.
That is so.
Amendment proposed, subclause 1, paragraph B, subparagraph II, line 2, after justice, insert not below the rank of a deputy director. I so move, Mr. Speaker.
Members, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Still on clause 44.
Speaker, rightly so. XXIV, clause 44, amendment proposed, subclause 1, paragraph B, subparagraph III, delete. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Honourable members, in the absence of any further amendment, I'll put a question. Those in favor of the deletion of subclause 1, paragraph B, II, say aye. Those against say no. The ayes have it. Subclause 1, paragraph B, subparagraph II is accordingly ordered to be deleted. Yes, Chairman, still on clause 44.
Rightly so, Mr. Speaker. XXV, clause 44, amendment proposed, subclause 1, after paragraph B, insert the following new paragraph as advertised on page 19. I so move, Mr. Speaker.
All members, the proposed amendment is for your consideration. Any further amendment to the proposed amendment? In the absence of any further amendment, I'll put a question to the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Yes, Chairman, your last amendment to clause
The last
44.
one, Mr. Speaker, XVI, clause 44, amendment proposed sub clause 1, paragraph C, delete and insert the following new clause. One chief nominated by the regional House of Chiefs of the region. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Now, honourable members, I'll put a question to clause 44 as variously amended in the absence of any further amendment. Yes, Honourable Baba Jamal.
Mr. Speaker, I'm looking at XXV, where the amendment that we adopted is a lawyer with not less than 7 years standing as a lawyer nominated by organizations of lawyers. Mr. Speaker,
Honourable Baba Jamal, we are in a learning curve.
Yes.
At the consideration stage, when a question is put
Yes.
on an amendment
Yes.
and the amendment is carried, you can only propose a further amendment upon the leave of the Speaker.
Mr. Speaker, that's exactly what I'm trying to do. To seek your leave to reconsider that position.
Very well, you may go ahead.
So, Mr. Speaker, I'm saying that if by organizations of lawyers, if we say organizations of lawyers, what do we mean by organizations of lawyers? Do we say it's organization by an organization of lawyers, so that we are specific on it, by an organization of lawyers? But if you say organizations of lawyers, how does it define it? But if you say, yes, but when you say organizations of lawyers, we have different organizations of lawyers. So, but we are not yet in a situation where we have an umbrella for all organizations of lawyers in Ghana. We don't have that umbrella of organizations in Ghana.
Honourable members, it's a legitimate issue that he's raising, so let's listen to him.
Yes, so because now we have a situation where we have the Ghana GBA, and now we have the Society of Lawyers and other organizations. So if we can say...
Is it the Law Society of Ghana or Society of
Law
Lawyers?
Society of Ghana.
So pronounce it well. Ghana Bar Association.
Ghana Bar Association
and
and Society of Lawyers. Mr. Speaker, what I'm trying to draw attention is that if we make it this way, if the rendition is this way, standing as a lawyer,
I think we get your point. Chairman of the committee, what do you say to it?
Nominated by...
In other words, Attorney General, what do you say to this? What do you say to the expression that he's indicating?
Mr. Chairman,
so now we have two organizations.
Yes.
Which one will do the nomination?
Mr. Speaker, in legislative drafting, the singular includes the plural. So there's no need to add organizations to it. I think there was some debate within the committee with respect to whether we could use the language or the expression association of lawyers, because of the fact that it might imply that this is a reference to the GBA or the Ghana Bar Association, instead of a generic reference to the Association of Lawyers in the region. So that is why the committee proposed instead to use organization of lawyers. But I do agree that instead of organizations of lawyers, we should be using one, like an organization of lawyers.
Very well. So you are proposing that we delete the S?
That is so, Mr. Speaker.
Or we delete the organizations and then replace it with organizations?
Mr. Speaker, you and the chairman, you are both Cavendish-trained legislative drafting
You are
experts.
also part of the Cavendish-trained legislative drafters. We went to the school together with you. So the proposal is to delete organizations and insert organization. Yes, Chairman. Chairman.
It's working now. It's working now.
Okay. Mr. Speaker, the intendment is to choose one lawyer, whether they are 10 organizations or not. However, they come together to get a lawyer to represent. And so the reason we use a plural, even though we're mindful of the drafting, the Cavendish training you and I attended, Mr. Speaker. And so Mr. Ward-Brew has an association. I don't know whether it's dead or it's still around. Plus the other one, Mr. Speaker. And there's a newly created association which we belong, Mr. Speaker. Proudly.
I understand all those things, but the question is that from which association or which association will do the nomination? Because there are two now.
Yes.
If the nominating authority, for instance, is Attorney General, we don't have a problem. We can only say that a lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. But this one, you say it should be nominated by a body, and we have two. Which one will do the nomination? That is the issue being raised by Baba Jamal.
Yes.
Baba Jamal, is that not the issue?
Yeah, that's the issue.
Yes.
So it is either, Mr. Speaker, if I propose, it's either we make it an organization of lawyers, or we take that confusion away, because it's likely that there can be even another organization of lawyers.
Yes, if you make it organization of lawyers,
That's right.
which organization are we going to expect
So we can give it
to
to
do the nomination?
So we can give
So
it to the
there is some
Attorney General to
uncertainty
nominate.
there. Yes, Honorable Sosu, let me hear you.
Mr. Speaker, I just wanted to draw your attention to the fact that we don't just have two, because we also have Lawyers in Search of Democracy, which is also an association of lawyers. So I think that to avoid the confusion, we can...
And it's likely we will have lawyers who doesn't belong to any of the associations.
Exactly.
In line with the principle established by the Supreme Court
Association.
In the case of Ward-Brew versus Ghana Bar Association.
Exactly. So I think we can reserve that to the Attorney General, so that we don't get involved into, which association a rep. So you still want a rep from an association.
Yes.
Yeah, so it means you can be in any of the association and be nominated to the yes.
Yes, Chairman of the committee.
Mr. Speaker, the intendment is that we want one person. We want one person, one representative.
Yes, the question, we agree on the intendment.
Yes.
Now the issue that we have to address, and we need your help, is that we have so many associations. Maybe tomorrow I'll be forming one. Which of the association will do the nomination?
Mr. Speaker, the intendment is that those associations will come together and nominate. Those
Don't you see a difficulty there?
Will come together.
Please,
and
please,
nominate.
please, please. Yes, Honorable James Akarga.
So, Mr. Speaker, in order to cure the mischief ably identified by my brother Baba Jamal, let us further amend the word association to associations, and further amend to read as follows. So if you have associations, then they will do the nomination on a rotational basis, so that in a given year, if Ghana Law Society is called upon to do the nomination, subsequently, the lot would fall on GBA to nominate. That is the only way to cure the problem. The problem. So let's have association.
Honorable members, with all due respect, the Attorney General at every point is the leader of the bar, whether the Law Society, whether the Ghana Bar, or whether Ahia Force Lawyer Society. The leader at all those places is the Attorney General. So I propose that the rendition should be a lawyer with not less than 7 years standing as a lawyer nominated by the Attorney General. Yes?
Okay. No.
Mr. Speaker, the committee is supposed to represent interest groups. This is the policy underpinning. It is a committee that represents interest groups. The committee is also, I believe, at the regional level. So the idea is that the committee is composed of representatives of the Attorney General, of the Human Rights Commission, and of lawyers practicing in the region. That is the idea. Lawyers practicing in the region. Lawyers in good standing practicing in the region. That's the objective. So you have lawyers, you have the Human Rights Commission, and you have the AG's office. They constitute the oversight committee. The oversight committee is established at the regional level. Yes, the oversight committee is established at the regional level. So in each region, you want the committee to represent the AG, the Human Rights Commission, and then lawyers in good standing practicing in the region. That is what the objective is. So lawyers in good standing practicing in the region will then develop a convention by which they meet to choose their representative. So that it's not done on the basis of associations, but on the basis of lawyers who have registered and are practicing in the region. Yes, they belong to different associations, but we don't want to be enacting associations. We don't want to be enacting associations. In fact, the whole idea is to move away from the enactment of associations. So you don't say Ghana Bar Association. Then you have Progressive Lawyer Association coming to take you on and challenging and going to court and saying that the legislation is discriminatory because it recognizes one association to the exclusion of another association. So the idea is to have representatives of lawyers in the region. So let's craft it so that the rendition captures the intent that the tribunal is a three-legged entity, one leg representing Human Rights Commission in the region, one leg representing AG's office in the region, and one leg representing lawyers practicing in the region, lawyers of good standing practicing in the region. So let's find a way of crafting it to reflect that.
So your argument is sound, but it appears impracticable. Impracticable in the sense that we agree that the lawyer 7 years standing at the bar should be appointed from the region. But who nominates that person? That is what we are talking about. So if you don't want the Attorney General, let's come out with a proposal that leads to how those lawyers are nominated from the region. Yes, Majority Leader.
See, when you say association or organization of lawyers. How about if in the region they don't have an organization of lawyers? You see, but you will have lawyers practicing in the region. And what I believe will happen if we enact that lawyers practicing in the region, a convention will evolve where lawyers who know they practice in the region will convene themselves to nominate somebody. Otherwise, then let's go to the old rendition where there is an association that everybody knows as an association of lawyers, and then say that they should nominate.
Majority leader, that will be vague. That will be vague. We need to give the power to nominate
Mr. Speaker.
To an entity.
Mr. Speaker.
Yes. Let me hear James Agalga.
So, Mr. Speaker, I can understand when the majority leader says we should not legislate on organizations. But the truth of the matter is that the Constitution itself allows for freedom of association. So that is a right which is already enshrined. And therefore, like it or not, the existence of organizations is something the Constitution already recognizes. And that is why I am saying that the real problem here is which of the associations. Now we are allowed to have a multiplicity of associations, bar associations. That is why we now have Ghana Law Society, Ghana Bar Association, and World Bruce Association of Lawyers. So how do you legislate to ensure that none of those associations or organizations enjoys a monopoly when it comes to the question of nominating lawyers for purposes of appointment? And that is why I propose that let us allow the organizations with S, the plural, to stand.
So,
and then,
in that case, for the purposes of being nominated, you are compelled to belong to an association.
Well, Mr. Speaker, in this country, practically, do we have lawyers who don't belong to?
If you read the principle established in the case of World Brew versus Ghana Bar Association, the Supreme Court says the Constitution guarantees freedom of association.
Yes.
So membership is not compulsory. So you can be a lawyer and decide not to belong to any association. Because the Constitution guarantees freedom of association.
Yes.
So if we adopt your rendition, it means that for you to qualify, you must belong to an association.
Mr. Speaker, practically, we have had Ghana Bar Association all this while. Mr. Speaker, most legislations clothe the Bar Association with the power to nominate. Have we ever had a situation whereby somebody who is not a member of the association found it necessary to raise questions about
yes, if you look at the history
of the Bar Association?
If you look at the history of it,
yes,
until recently, the only association is the Ghana Bar Association. And there is a compulsory nature of it until the matter has been taken to the Supreme Court. That's why so many associations are now coming. So the monopoly is broken. At first, it's as if you can't call yourself a lawyer until you belong to the bar. That is why we normally say, like this one would have said, good standing at the bar.
Mr. Speaker, look here.
Yes.
Mr. Speaker, because our colleagues have left the chamber, you are minded not to be looking at this place. You don't expect them to be here, but please, I'll urge you to be looking at this side small. Mr. Speaker, you made a proposal.
Well, let me advise you. The rules allow that when we are at the consideration stage, you can move from wherever you are sitting to group.
Okay, so that I can get closer.
But, yes, but apart from the consideration stage of a bill, you must get up on your feet and catch the eye of the speaker to speak.
That's right.
The only dispensation granted by the rules is at the consideration stage of a bill.
Yes.
So normally what happens is you move to an area where people who do advocacy in favor are. So next time I will advise you to do that.
I will take a clue from that. Mr. Speaker, you made a proposal which got very close to resolving this matter. To avoid this confusion about associations and organizations, and taking into consideration the fact that Attorney General itself will be maybe represented on the committee, can we look at it from this aspect? The nomination will come from the Attorney General, all right, but it should be from the private sector. So we can have a private legal practitioner nominated by the Attorney General. So even when Attorney General is represented, you have a private legal practitioner represented, so that we don't run into the problem of these associations. Because as for the association, once the gate is open, more associations will come in. So I want a recognition, as you know, nominated by that a private legal practitioner nominated by.
No, that in our context, if you are talking about a private legal practitioner, a corporate lawyer in Baba Jamal and Co. Is he also qualified to be a private legal practitioner?
Maybe I will use a different phrase instead of the private legal practitioner. Maybe we see from the private sector or something. But whatever I'm saying is that it should be a private legal practitioner nominated by the Attorney General. So we avoid this problem of these associations, and so we make it specific. So the Attorney General can nominate any private legal practitioner practicing in the region or in the whatever at any point. So it should be a private legal practitioner, a private lawyer, a lawyer who is not working in government or whatever. It should be a private legal. If we do it that way, we will get it specific.
Yes, Chairman of the committee.
Mr. Speaker, I think we have flogged this clause for some time now. My suggestion is that once it is a regional oversight committee, we should give that power to nominate to the supervising High Court judge in the region. The supervising High Court judge in the region to nominate a lawyer with not less than 7 years standing. That's it. And so we can leave out the association. So a lawyer may belong to association or not. And so that this excludes lawyers who don't belong to any of these associations.
Yes, the proposal is that we give that function to the judiciary to perform.
For the supervising High Court judge in the region.
Chairman of the, yes, Majority Leader.
Mr. Speaker, we say that there are issues with the traditional court system. We are creating a tribunal. Then we'll go and say that the High Court judge, who is of the same qualification as the chairman of the tribunal, he should appoint somebody to supervise the chairman of the tribunal. How can we do that? How can we do that? How can we say that the High Court judge should appoint somebody? Yes, that's what we're saying. He should nominate a lawyer to serve on the oversight committee that is oversighting the tribunal in the region. And you are saying that the High Court judge, supervising High Court judge in that region, should be the one appointing a lawyer to supervise the tribunal chairman. So we can say the Chief Justice, but not the supervising High Court judge in that region, because he is of the same stature as the tribunal chairman. Their qualifications are the same. So why should he be the one appointing a supervising, committee member?
So, honourable members, we defer the clause because the qualification of the chairman of the tribunal is equivalent to that of the High Court. You are going to appoint a lawyer 7 years to supervise? Yes, to serve on that particular committee. How we owe fidelity to seniority at the bar? Yes, Attorney General.
Mr. Speaker, this is a committee, and the committee can benefit from the wisdom of the legal practitioners, and it doesn't matter that the legal practitioner is 2 years. No, we are saying 7 years, because under Act 32, that is the point at which you are allowed to practice on your own. So a person like that can serve on the committee. And it's an oversight committee that is more or less monitoring and evaluating the work of the tribunals. At the Legal Profession Act. So
yes, it's just like asking Shaibu to evaluate and supervise your work.
Mr. Speaker, pardon me.
It's just like asking Shaibu as a lawyer to evaluate and supervise your work as Attorney General.
Well, no, Mr. Speaker, I think the collective wisdom of the committee is what we are driving at.
Very well.
Not necessarily the individual members of the committee.
Very well.
And remember that we have the Commission on Human Rights and Administrative Justice on it. Okay, and we have a representative from the Judicial Council nominated by the Chief Justice.
So who does the nomination? Yes, let me hear from Honorable Bid Asidi. I want Azuma.
Mr. Speaker, if you look at the membership of the committee, they are nominated by bodies or institutions. So in the case of the Judicial Council, the Chief Justice nominates somebody from that place. The Commission on Human Rights and Administrative Justice, the Commissioner nominates. There is a representative to be nominated by the Regional House of Chiefs or the National House of Chiefs. And also, the Chief Justice will have to nominate 2 persons, at least one of whom is a woman. So the Chief Justice has been given the opportunity to nominate people from the Judicial Council and at the same time from the public. So I don't find anything wrong if we give that authority to the Chief Justice to nominate any lawyer from the region. So then we have solved the problem of having to ask the various associations to come together to nominate. The Chief Justice takes that responsibility and exercises it. And then he just picks a lawyer from the region, and then the lawyer will be part of the oversight committee. So, Mr. Speaker, that is my proposal.
Very well. It's for the consideration of the House. Yes.
Mr. Speaker, when you look at what we are talking here, we are looking for a lawyer who is maybe practicing lawyer. The Attorney General is the leader of the bar. It is a lawyer we are looking for. Attorney General is the leader of the bar. So if Attorney General is the leader of the bar and we want a lawyer, who will be the best to select somebody to represent? That's why we are, and from the bodies that have been selected, the only people who are not represented is the private lawyers, is those who are practicing. So can't we say that the Attorney General will nominate a private lawyer to represent on the committee, so that the lawyers who practice in the region will have a representative on the committee, nominated by the leader of the bar. So he should nominate. Yeah, the leader of the bar should nominate. So I think that if we do it, now I move that the rendition should be raised, Mr. Speaker. I think it should be a private lawyer with not less than 7 years standing. A lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. Simple. The Attorney General will look through the lawyers.
Honorable Chairman.
Yes.
Mr. Speaker, I am minded to support this.
I've made this amendment long ago.
Yes.
I'll put a question.
Back to your amendment. AG.
Yes.
Hey, James.
That my colleague Baba Jamal used the word private.
Please,
yes.
please.
Oh, you've taken it out.
Please.
Very well.
He took it out.
I heard it, yes.
No, he took it out. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is carried. Now I'll put a question on entire clause 44 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 44 as variously amended is ordered to stand part of the bill. Clause 45.
Functions of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendments. No advertised amendments.
It is for the consideration of the House. All members, any proposed amendment to clause 45? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 45 is ordered to stand part of the bill. Clause 46.
Tenure of office of members of the committee.
Chairman of the committee.
Mr. Speaker, I think I jotted something small on 46.
We are not interested in what you jotted. Just tell us the amendment.
Mr. Speaker, 46(5), line 3, after inability, insert of the member.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Any further amendment to clause 46? I'll put a question on entire clause 46 as amended. Those in favor say aye. Those against say no. The ayes have it. Clause 46 as amended is ordered to stand part of the bill. Clause 47.
Meetings of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. All members, any proposed amendment to clause 47? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 47 is ordered to stand part of the bill. Clause 48.
Disclosure of interest.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 48. As many as are in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 48 is ordered to stand part of the bill. Clause 50.
Supervision of tribunals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any proposed amendment to clause 50? In the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 50 standing part of the bill say aye. Those against say no. The ayes have it. Clause 50 is ordered to stand part of the bill. Clause 51.
Annual reports.
Chairman of the committee.
Mr. Speaker, Clause 51, amendment proposed, subclause 1, line 3, after the insert committee and. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendments? In the absence of any further amendment, I'll put a question. Those in favor of clause 51, those in favor of clause 51 standing part of the bill say aye. Those against say no. The ayes have it. Clause 51 is ordered to stand. Clause 51 as amended is ordered to stand part of the bill. Clause 52.
Record keeping.
Chairman of the committee.
Mr. Speaker, Clause 52, amendment proposed, subclause 1, line 2, delete audio and insert electronic.
The proposed amendment is for the consideration of the House. Any further amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on entire clause 52. Those in favor say aye. Those against say no. The ayes have it. Clause 52 as amended is ordered to stand part of the bill. Clause 53.
Ethics and integrity.
Chairman of the committee. Chairman, clause 53. Please, who is putting the microphone on?
Mr. Speaker,
Yes.
no advertise amendment.
You are sitting down, you are not even voting, you are complaining of being tired. There is no advertised amendment to clause 53. I would therefore put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 53 is ordered to stand part of the bill. Clause 54.
Immunity of chairman and members of tribunal.
Chairman of the committee.
Mr. Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 54? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 54 is ordered to stand part of the bill. Clause 55.
Modification of enactment.
Chairman of the committee.
Mr. Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 55? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 55 is ordered to stand part of the bill. Clause 66.
Regulations.
Mr. Speaker, 5-6.
Chairman of the committee. No, I said 56.
Clause 5-6.
Yes. 56.
The Speaker, amendment proposed, subclause 1, line 1, delete Chief Justice may and insert Minister shall within 12 months after the coming into force of this act. I so move, Mr. Speaker.
Our members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 56 is ordered to stand part of the bill. Now I'll put a question on entire clause 56. As many as are in favor say aye. Those against say no. The ayes have it. Clause 56 as amended is ordered to stand part of the bill. Clause 57.
Interpretation.
Chairman of the committee.
Mr. Speaker, amendment proposed after interpretation for Judicial Council, insert the following new definition. Minister means the minister, the Attorney General and Minister for Justice. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 57. In the absence of any further amendment, those in favor say aye. Those against say no. The ayes have it. Clause 57 is ordered to stand part of the bill. Honourable members, Clause 58.
Consequential amendment.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 58. Those in favor say aye. Those against say no. The ayes have it. Clause 58 is ordered to stand part of the bill. Clause 59.
Savings.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, clause 59 is ordered to stand part of the bill. The schedule.
Timelines for determination of a case under the Minerals and Mining Act 2006 at 7:03.
Chairman of the committee.
Speaker, schedule, proposed amendment, delete. I so move, Mr. Speaker.
So I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. All members, the ayes have it. The schedule in the bill is accordingly ordered to be deleted. All members, we come to the long title.
An act to provide for the establishment, jurisdiction, composition, and operation of tribunals in accordance with the Constitution, establish the Tribunal Oversight Committee, and for related matters.
Yes.
Speaker, may I crave your indulgence and seek your permission to take us back to clause 25.
To
page 17, clause 25.
Very well,
of the other paper. Speaker, we propose a new rendition for 25, that's inserting the new sub-clause. We propose that the tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. This is a new rendition we want to replace.
So are you deleting and inserting this?
Yes. So we're deleting.
You are making it as an additional clause.
And inserting this. Did we? Yeah.
You see, Honorable Shaibu.
Yes.
As a man, you have to speak for your vocal cord to vibrate. You speak for your vocal cord to vibrate.
Speaker, very well.
So the question therefore is, are you proposing?
Yes, I am.
That
we delete
the entire clause 25,
the entire,
as in 1 and 2,
yes,
be deleted.
Yes.
And in place
of it, we have the following rendition.
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move.
AG, what do you say to this amendment?
Mr. Speaker, I agree with the chairman's amendment.
Very well, I'll put a question. Those in favor say aye. Yes. You see, that's why I ask, are you deleting 25 as in 1 and 2? The drafter is saying that 25.1 is staying. It is 25.2 that they are recrafting. Because the 25.1 is cross-referencing the very procedure in the criminal and Other Offences Act. So what do you say? So your proposed amendment is delete clause 25(2) and replace with a new rendition. Do you want to come as second consideration?
Yeah. So, Mr. Speaker, may
Yes,
I just
leader.
go over it again?
Leader.
24, the new subclause has two components. We are maintaining the first component. It's the second component that we are deleting and replacing it with the new rendition.
Yes, but that wasn't what you said initially.
Very well.
That was not what I was going to put a question on. So, honourable members, for the record,
Yeah.
the proposal is to delete 25(2)
25(2).
and substitute it with a new rendition
Very
as
well.
read by the chairman. The proposal is to, yes, and we have not taken it. We have not taken this amendment. We've taken this amendment. We have taken this amendment.
Yes. So it's session.
Yes.
So they say after session.
So is this what they are further amendment?
So they say 25 so it's a new session they're having.
So, honourable members, the amendment actually is not to delete clause 25. He said after subclause 1, insert the following new clauses. So it's an insertion after subclause 1, as in page 17. And page 17 is in twofold. One, the Evidence Act 1975, NRCD 323, applies to the proceedings of the tribunal. 2, an order issued by the tribunal shall ensure compliance with rules of procedure and guarantee a fair trial. So in this case, it is the insertion that you are further amending in 2. Is that it?
So, Mr. Speaker, in 2, we are just deleting the 2 and inserting the new rendition.
Very well.
Yes. So we are taking away an order issued by the tribunal, the whole of the...
Honourable members, the chairman is not speaking loud, and you are also speaking.
Mr. Speaker, the 25 has two components, 1 and 2. We are not touching 1. We are replacing 2 with this new rendition. And may I go over it again?
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move, Mr. Speaker.
Very well. Honourable members, the proposal is to further amend the proposed amendment at page 17 of today's order paper to insert. Yes.
Mr. Speaker, my understanding is that first he is adding 2 new subclauses.
Yes.
Then, if he does that, subclause 2 now becomes subclause 4.
No, you leave that for the
Yeah,
drafters.
I'm coming. So what he's trying to amend is the existing subclause 2. Not replace his amendment. No. The existing subclause 2 is what he seeks to delete and then prefer a new rendition.
Chairman, is that the case? If that is the case, why are you drawing our attention to clause 17? Yes, so leader, there are amendments to clause 25, as in page 17, which amendment has been carried by the House. And this amendment is the insertion after subclause 1. 2 provisions which are inserted, so the numbering will change. Now, what the chairman is seeking to do is to further amend his proposed amendment that has been carried in the second part. Just leave the renumbering for the drafters. So it is not the original 2 that chairman is amending. Chairman, is that the case?
Yes, we're further amending, yes, because it says an order issued by the tribunal shall ensure. It's not the order that shall ensure, but the tribunal, yes. So it is a tribunal that will ensure. That is why we are changing that.
So I'll put a question. Those in favor say aye. Those against say no. Honourable members, the proposed amendment to the chairman's amendment in page 17 of the order paper for today is ordered to stand part of the bill. Honourable members, since it has got to do with clause 25, I must put a question on the entire clause 25 again. Those in favor say aye. Those against say no. The ayes have it. Clause 25 as variously amended, including the further amendment, is ordered to stand part of the bill. Now, the long title has been read. Any proposed amendment to the long title? Or it has not been read? Yes.
Speaker, it's been read.
What is the amendment?
The long title has been read.
You said, is there any amendment to the long title?
No proposed amendment, Mr. Speaker.
Honourable members, in the absence of any proposed amendment to the long title, I'll put a question. Those in favor of the long title standing part of the bill say aye. Aye. Those against say no. Honourable members, yes, the Attorney General. Honourable members, the ayes have it. The long title is ordered to stand part of the bill. And honourable members, this brings us to the end of the consideration stage of the Tribunal Bill 2026. Yes, Majority Leader. Any more business?
Mr. Speaker, Mr. Speaker, you've taken the... We are finished with consideration stage.
Yes.
Yes, so Mr. Speaker, we want to take item number 28.
Mr. Speaker, honourable members, welcome back. You may take your seat. Yes, Majority Leader.
Mr. Speaker, we want to take motion advertised on page 20, numbered 28, to abridge time so that we can take the Tribunals Bill 2026 through the third reading.
Motion number 28. The Attorney General and Minister for Justice.
Mr. Speaker, may I move that notwithstanding the provision in Order 172, Sub-Order 1 of the Standing Orders, which requires that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least one sitting day has elapsed. The motion for the third reading of the Tribunals Bill 2026 may be moved today. I so move, Mr. Speaker.
Honourable members, motion ably moved. Any seconder?
Mr. Speaker, I beg to second the motion.
Honourable members, motion moved and seconded. It is for the consideration of the House. This is a procedural motion. The question, therefore, is as many as are in favour of the motion say aye. Those against say no. The ayes have it. The motion is carried. Now the consequential motion is 29.
Mr. Speaker, may I
Attorney
move
General and Minister
that
for Justice.
the Tribunals Bill 2026 be now read the third time. I so move, Mr. Speaker.
All members, motion move. Any seconder?
Mr. Speaker, I beg to second the motion.
All members, motion move and seconded. It is for the consideration of the House. I'll put a question. As many as are in favor of the motion number 29 at page 20 of today's order paper say aye. Aye. Those against say no. All members, the motion is accordingly adopted.
An act to provide for the establishment, jurisdiction, composition, and operation of tribunals in accordance with the Constitution, establish the Tribunal Oversight Committee, and for related matters.
Honourable members, the Tribunal Bill 2026 is now duly read for the third time and passed. Yes, Majority Leader.
Mr. Speaker, I want to thank members for their perseverance. We are now officially in Friday. So it means that members sat since yesterday, actually doing a 24-hour economy work, and have passed a bill that is a major commitment of the National Democratic Congress. we campaigned on this particular proposal that if voted for, if elected into office, we will establish the tribunal system of the administration of justice. This message was overwhelmingly voted for by the people of Ghana. I believe that those who today are questioning our decision to enact this law are in effect questioning the judgment of the several millions of Ghanaians who voted the NDC into office. We as a party will remain true to the commitments that we made to the people. And so let me commend members. We know that Ghanaians want to have confidence in the administration of justice. We believe the setting up of tribunals will go a long way to restore confidence in the administration of justice. Let's give the tribunals an opportunity. Let's shape it and make it deliver expeditious administration of justice, which we believe will engender public confidence in our democracy. So I want to thank the Speaker for persevering. He has been sitting since yesterday and has so ably steered the affairs of this House for us to arrive at this successful passage of the bill. So, Mr. Speaker, I want to thank you for your effort, your endurance, your perseverance, your tolerance. You have tolerated a lot to get us to this stage, and we want to commend you for your tolerance. Colleagues, I cannot say any more how pleased I am with your actions since yesterday. Some of our colleagues were in the voter regime and did whatever it took to arrive back in the chamber to be able to enable us constitute the quorum. Others were actually in bed when we called, and they had to leave and come and join us. Come and join us to pass this bill. As for the table office, they have been sitting in the chamber since 2 p.m. yesterday, and we have to commend them, led by the clerk, who has provided invaluable guidance throughout the passage of this bill. I believe that all the concerns that civil society groups have been adequately dealt with, and I urge civil society groups to take a look at the bill and the various provisions of the bill, and if there are concerns, I believe that this House is a listening house and we can revisit some of the issues that they are concerned about. But for now, we believe that we have provided Ghana with the best framework for a tribunal system of administrative justice as one can possibly have. Lastly, let me commend and thank our journalists, our media, our press corps. They have been with us since yesterday, and I believe that we need as a House to commend them for being with us through thick and thin as we worked towards the passage of this bill. Mr. Speaker, I want to urge colleagues, when driving home, please drive carefully. I believe that we are all very tired and might be sleepy, and so drive carefully back home. Mr. Speaker, the Attorney General says that during the day we will all smile. Thank you very much, Mr. Speaker.
Honourable members, clearly we have sat from 12 o'clock on the 16th July 2026 to 12 o'clock 17th July 2026. Definitely, we have done more than 5 hours. In the circumstances, I have the authority to adjourn the House based on Standing Order 56-2. I therefore adjourn the House till Friday, 17 July 2026 at 12 noon. In other words, I adjourn the House to today, 17th July 2026 at 12 noon. Thank you very much, honorable members, for your patience.